Okay, let's talk about Kennedy, and obviously we're talking about religion here, school prayer, that football coach, that public high school, constitutional right to pray at the 50-yard line?
Yeah, Coach Joe you're talking about here, Coach Joe Kennedy.
Yeah.
And he was this coach, and what he said is, I want to go pray at the 50-yard line. And the key here, though, is the difference between reading the dissent, which is with the people that lost the Supreme Court case, versus the people who wrote the majority opinion. Why? Because the dissent told us, hey, he was praying with other people, he was doing it for years, he did it in the coach in the locker room. But the majority said, listen, he got told to stop doing all that stuff, and there was only 3 times that he prayed where he got fired for, and he prayed in silence without his team when his team wasn't there. If you take the majority's opinion here on their facts, you'll realize, hey, we're not going to see prayer everywhere around school. You're only going to see prayer when someone's on their own personal time. That's the rule. When they could check email, when they could talk to friends, when they could go to lunch break. That's where prayer is permissible. It's not to indoctrinate our students.
All right, but we do have another ruling, this one about religious schools and that state tuition. It's a Carson versus Mencken court ruled that a Maine program that excludes religious schools from a state tuition program is a violation of free exercise of religion.
It's a problem with my ADD on that. All I heard was Maine, and I'm thinking about lobster rolls. But I'll go back to where you're going. I was like, I need a lobster roll. But what this case basically says is, hey, in Maine, I don't know if you've driven around Maine, but you could drive a really long time before you find a school. Like it's country. And so they said there's places where they don't have secondary schools, and people could pick their own secondary school, and the tax money would go to that school that you're going to go pick for your kids. And all this law says is you can't prevent someone who's picking their own school from picking a religious school. We've heard from a lot of people that says, hey, now it's got to pay for religion that the state's indoctrinating us with. The state's picking the religion. But the key on this case, the parents pick the school. So it's not that they're forcing from the state to pay for religious schools. And that's a major distinction.
All right, on the court docket, looking ahead for the next term, obviously we're going to have a new justice on the bench, but one of the things that's up there is a case that could mean the end of using race as a factor in college admissions.
Yeah. So the real question, though, is, are we using race to do what we traditionally think about affirmative action, where we're trying to give disadvantaged people a leg up? And I'll have you know that that's never been the case. That's not the basis of the law. The law is that if we have a more diverse student body, do we have a more robust exchange of ideas? When people different than you are the people you're talking about to, does that make learning better? We're New York, we're the melting pot, the tri-state area, we get that. And all the case is saying is, has there been enough diversity now that we don't need to help push more diversity because there's already a robust exchange of ideas? So we need to look at why they have the law. That's going to be on the next term. It's going to be a fascinating one, and I can't wait to break that down for you next year.
Yeah.